separation of power is it completed?
It is a misnomer. Misnomer are wrong understanding. People think that quasi-judicial body means any body which has a power of civil court. But we don't have to understand that way. Rather, a quasi-judicial body is one which, even if it has mixed features of both, but its style of functioning will be judicial in nature. So all those bodies which style of functioning is not judicial in nature will not be considered quasi-judicial body. Right. But we have found people write in answers any body as. So this is what we want to clear. So merely a power of civil court does not make a body as quasi-judicial body. Although general language जो होता है, जो generic language जो लिखा जाता है, in generic language, general language, abstract way, it is told that they are quasi-judicial body. Like a newspaper वाला भी ऐसे ही लिखेगा. This. So it is very important to understand the conceptual differences. Like that same thing happens related to interest groups, pressure groups, civil society, non-governmental organization. Question है civil society का, people are writing on interest groups. Question है interest groups, people are writing on civil society. Right. Even self-help group का example देते हैं लोग NGO का. So conceptual understanding should be, let's say, means we should understand. So we are trying to understand that first. So what is that? Let's categorize like a quasi-judicial body, non-quasi-judicial bodies. So quasi-judicial bodies. Right. It is just for your understanding. It is not for means it is not something, let's say, it's not a go question is going to be asked in that way. So, by this, you should understand. I guess things are clear now. So, if we treat both as the same, you know what we are doing. So let's take one by one what we are saying. Their style of functioning is judicial in nature. What do you mean when we say judicial in nature? The judiciary has benches. It functions through benches. Single bench, double benches. Let's say single judge bench, 2 judges bench, 3 judges bench, depending on that. They will also function through benches. Single member, double member, whatever. But they don't function like benches. CVC does not function. It does not have that practice. NHRC does not have that practice. Then power of contempt. They have judicial powers. Even if they have administrative features where they resemble more towards judiciary rather than administration. Why? Because they have been given high court's jurisdiction. In past, the cases which were dealt by the high courts have been transferred to tribunals. So when in past or when you create a new tribunal, so it means that you are transferring the jurisdiction of high courts. It means the cases, if they are not created, tribunals are not created, tribunals are abolished, it means that those cases will go to high courts. It means that they will resemble powers like high courts. So they should have independence like high courts. This way you have to understand that they have been created, although I have written this point here. Then appointment, it means that appointment should happen by independent. The way appointment happened to judiciary, similarly there should be appointment to judges of that means tribunal in independent manner. Their condition of service should also be in that fashion. But their style of functioning is not in that manner. They don't have this power. They don't have power of contempt. This you can see this. It is not needed, although they should be independent. That we can write. There can be other conditions for independence. Right. They should also have independence. Then next thing is that when appeal, you know that there is a hierarchy of courts. So when we have a hierarchy of courts, an appeal goes there. So you don't have to think about, there will be an appeal. If the party is not satisfied, appeal will go. So appeal will go to the higher court. It can be high court or it can be Supreme Court, which will tell you at later stage in some cases what happens. But let's say Election Commission. The Election Commission of India will hear a dispute related to election. Let's say Model Code of Conduct. The Election Commission of India will enforce Model Code of Conduct. While enforcing Model Code of Conduct, it has power of civil court. When it has power of civil court, it can summon. It can summon. And when it can summon, let's say any person, the person who is, let's say the said person, and it can censure that person. It can even order for disqualification. Right? It has power. But its appeal, there is no clear, let's say that. Thereafter, if you read Election Commission of India, it is not mentioned that against Election Commission of India judgment, appeal will be filed in this court or that court. Right? So, although the person can move on some other grounds either to Supreme Court or to High Court. Let's say कि MLA is disqualified in Delhi, by Election Commission advice they went to High Court. The clear jurisdiction will not be mentioned. Right. The Election Commission recommendations are not binding in some cases. Only in electoral disputes enforcing Model Code of Conduct during election time, it exercises power of civil court. In general, it does not have power of civil court throughout the year. Only when Model Code of Conduct, when it is, let's say, redressing any dispute, then it becomes. It means that its civil court power is not a major function. their civil court power is a minor function which is needed at times. Right. Otherwise, their major function is different. Its major function is administrative, to conduct elections free and fair. Right. This you should know. But their major function is dispute redressal. Their major functions are not dispute redressals. But their major functions are only they are meant for dispute redressal. So dispute redressal, you can say that 100% dispute redressal. If you take their 100% role is dispute redressal. If you take like this, it's very difficult to define, but it can be 10% dispute redressal. Rest they are for other things, like say NHRC. NHRC has no dispute redressal. Its jurisdiction is also not defined. Do you know appeal will go to? It is not defined. CVC, recommendatory body. In fact, it is recommendatory body. Right. But CIC, see the diversity. There is no one uniformity. In case of CIC, it's decided, Delhi High Court. Its appeal will go to Delhi High Court, it is defined. But it is not quasi-judicial body. Right. Why? Half of the members are not judges. It does not function like benches. Right. It does not have contempt power. Its function is not judicial in nature. Right.
In case of CBC?
Yes.
And what about CIC?
Yes, it's also not judicial in nature. It is not judicial in nature. So even if it is defined, but one characteristic is still it will not make it quasi-judicial body.
In order to be a quasi-judicial body, all the characteristics.
Yes, you have to match all the characteristics. In fact, simply saying that functioning in judicial nature itself is adequate. Right, judicial nature, because they have been given cases of high courts. They deal with cases of, right, CIC does not deal cases of high court. It deals with RTI related cases. Right. Anyhow, then half members, this is how we have mentioned, this then can deal with substantial, yes. Substantial nature means they can deal with also interpretation of law. It has power to interpret law. This you should know. A quasi-judicial body. But they don't have such power to interpret law. And they are created to this. So, this we have to understand. Their main purpose of creation is different. Those who have civil court powers, and means those who have given civil court powers, so their purpose of creation is different. They have been created to perform some other functions. While performing some other functions, they need at times invoking of civil court powers, so that they can enforce their investigation, they can carry out investigation. This, like say National Commission for Women also will come in this category. Right. National means all those bodies will come like this. Like why we have formulated National Commission for Women? Not to adjudicate case. We have formulated for protection of women rights and promotion of, right, gender empowerment. It will deal basically gender related case. And its main role is not to hear and adjudicate gender related. It is not a court at first place. Right. It is an institution at first place to promote gender empowerment. While promoting gender empowerment, it will also deal grievance related to gender. Let's say a human right violation related to women. What at best it can do? It can seek a report. It can carry out investigation. While seeking report and carrying out investigation, it can summon people. To summon people, that time it needs power of civil court. So that it can adjudicate, means it can enforce its summon. Right. This similarly, Human Rights Commission to protect human rights. It is not an institution at first place to hear disputes related to human rights. Rather, it works for protection of human rights. Protection means it is a watchdog. It will see where human rights violations are happening. It will seek report and intervene. Right. It will intervene and so that corrective measures are taken. It will promote awareness related to human rights. It will carry out various types of publications, meetings, conferences, and it will create awareness among people. Then it will carry out research. It will study government laws related to human rights, and it will suggest to government how the laws can be improved, policies can be improved. While dealing all these things, it may also come across the issues and incidents where human rights violations have happened, and it carries investigation itself. It will carry out investigation. When it carry out investigation, then it can recommend corrective measures. While recommending corrective measures, it may need civil court power. This what? To summon people, to get evidence. This. But once it carry out investigation, it gives recommendations. They are not binding. They are recommendatory in nature. This we have to understand. And that is how just I told 1, 2, 3 stories like this. So their members, even if it is headed by a judge, retired judge, it has also some other judicial members, bureaucratic members. So some of them may fulfill 1 or 2 points. But still those 1 and 2 points will not make them functioning in judicial in judicial nature. Judicial nature simply means that you have to function like benches, 1 judge, 2nd judge, etc. You deal directly with dispute redressal, and your cases are related to the past cases of high courts, and this is how you have to, and after your adjudication, cases will be further appealed in high court and supreme court. This. And that is how judicial proceedings, the quasi-judicial bodies proceedings are nothing but judicial proceedings. It has recognition of judicial proceedings, but their proceedings have no recognition as they have judicial proceedings. Only when civil court they are functioning, that time they can work as a bit judicial nature. Like say election commission is administering election, its main role is administering election, registering political parties, preparing electoral roll, managing electronic voting machines. So these are the main roles. So its major role is different. That way you have to understand. While doing that, it has a role of at times dispute redressal. This you have to understand. And that is how, let's say, there is a difference between quasi-judicial bodies and other such bodies which have power of civil court. Means all those bodies which have power of civil court will not be considered quasi-judicial bodies, because only some of them have the nature of judicial functioning, and that's why only those bodies will be considered quasi-judicial bodies. Can we say? So let's write few lines on this. Therefore, all bodies having power of civil court, all bodies having power of civil court would not be considered quasi-judicial bodies, would not be considered quasi-judicial bodies in a strict sense. Strict sense. Rather, quasi-judicial bodies resemble judiciary in terms of their style of functioning. In terms of their style of functioning. And therefore, their characteristics or features are different from other bodies which have power of civil court, which have powers of civil court. So when we are talking about, when we are talking about quasi-judicial bodies, we are talking about them. Our discussion will not be about them. Right? Our discussion has nothing to do with them. Our discussion has to do with them. Means when we will further proceed on quasi-judicial body. Now you should know that it is because of this issue, appointment related, this Supreme Court has almost fought with executive. Right. This has become basis. Once they struck National Tax Tribunal and Intellectual Property Appellate Tribunal. Two tribunals were struck down by Supreme Court on the grounds that they have not been given independence. It can be 2014, 13, there was debate, or 12, 13, yes, in 13. This. And right now they are fighting for this again, independence related to restructuring of tribunals. Bill 2021, the dispute which is going on. We'll come to that point. So in past, the characteristics are having sacrosanct, like they don't want to compromise on that, because compromising those things will result into huge repercussion, which we'll talk later on. You should also know that once Supreme Court considered CIC as quasi-judicial body. Once Supreme Court considered CIC, a case was filed in Supreme Court that CIC should be considered also as a quasi-judicial body. So Supreme Court gave judgment as per the petitioner, means petitioner expectation. And you know what told when it said it should be quasi-judicial body? It went on saying that CIC should have henceforth half members as judges. They defined that half members should be judges and it should function like benches. The way judiciary functions at other tribunals, it will function through benches. This you should know that. After 1 year, it itself quashed its judgment. Right. And it told that no, it is not a quasi-judicial body. Because the nature of functioning of such institutions does not demand that they should become judicial type. The day you will make such institutions judicial type, so they will become more rigid. There will be more judicial dominance. It is not needed to have every dispute redressal as judicial way or in judicial manner. Like say RTI related disputes. RTI related disputes do not demand judicial way of redressal of dispute. Already there is a High Court, Supreme Court scrutiny, appeal will go. So then it is not needed, because half of the members, the one, let's say that CIC has 10 plus 1 member. Plus you have, let's say that number of states 28. So 10 plus 1. So just calculate how much. It will be like, if you go by simple mathematics, 280. Plus let's say that 11. इतने तो जजेस भी नहीं होंगे हाई कोर्ट में, बाद में पता चला. इसके हाफ मेंबर यू हैव टू हैव. The half member is, let's say that at least 160 plus. 160 plus judges will be holding position in information commissions. And it told that retirement age would be 65 years. Right. The Supreme Court retirement age is 65 years. Judgment was found a bit, let's say, problematic. Hence it itself, let's say, quashed its order. Anyhow, so I guess it is clear at this stage you are able to understand what is the difference between quasi-judicial body and bodies which have power of civil court but they are not quasi-judicial bodies. Right? Now, another minor thing is when we say tribunal, tribunal is equal to quasi-judicial body. Either you speak tribunal or you say quasi-judicial body, it means the same thing. Right? So, all those which we are referring as quasi-judicial body, they are also considered a tribunal. Like say Central Administrative Tribunal. What we say Central Administrative Tribunal and Green Tribunal, NGT, National Green Tribunal. Right. This Security Appellate Tribunal for SEBI, Telecom Appellate Tribunal. This. So whether you see quasi-judicial bodies, company law, this is our National Company Law Tribunal. This. So we do not refer, we refer interchangeably or will speak, let's say, quasi-judicial bodies. This. So that is how we will deal it. Next is called need for such. Why do we need such bodies? Need for quasi-judicial body. See, separation of power, I do not know whether I have completed what extent.
So we are only in rational spirit.
So we dealt conceptual aspect. Let's deal quasi, then we'll deal it. While dealing this, whether quasi-judicial body is a violation of separation of power, so thereafter I can deal that. Need for this. Simply you understand, then I will tell the points like judiciary. If you see from today's perspective, it is very clear that judiciary is highly overburdened. Right. So judiciary, one thing is that it is highly overburdened, 3.9 crore cases. Right. It is highly overburdened. It needs to be relieved. Right. So first point can be itself that overburdened judiciary. इसको भी अल्टरनेटिव डिस्प्यूट रिड्यूसल बोला जाता है, ADR. So we are partly doing ADR, although after this we will formally talk about ADR. Right. Then next, so some disputes, let's write. some disputes do not necessarily need adjudication in pure judicial manner. Rather specialized adjudication. Right, next. Speed and efficiency. Such cases also demand speed and efficiency. As delay will seriously hamper those cases related outcomes. Cost effectiveness. Since adjudication is done by application of natural justice rather than civil procedure code. Hence, it saves cost of adjudication. Including legal representation of both parties. Next, due to development, technological advancement, and need for competitiveness of economy. It has become an essential practice. Next, judiciary has legal sense, but nature of disputes are increasingly becoming commercial, technical. Therefore, primarily because of speed, efficiency, cost effectiveness, specialized adjudication. Quasi-judicial bodies have become essential part of any judicial system as ADR mechanism. benefits भी वही होगा फिर. Either you talk needs, the needs will be also benefits. Same thing, this is how you can write. Benefits are that cost effectiveness, speed, efficiency, specialized adjudication, reduction of burden on judiciary. This way you can write. So basically the first thing that you have to understand that all cases do not demand that we should go for redressal of disputes the way it is done by judiciary. Right. Judiciary has its own process procedures which are considered as civil procedure code. This civil procedure code. Civil procedure code decides the process and procedures of case in the judiciary. How the case will be filed, how the case will be processed, right? And the, let's say that key channel, duration, representation, the advocates, right, evidence, all these things. It is called civil procedure code. The civil procedure code decides the process and procedures of judiciary, or they decide the judicial process. Hence, it is itself a time-taking device. This is first. Second, judiciary has legal sense. It looks into the legality of the case. But many disputes are, let's say, technical, specialized. So when technically specialized, let's say someone has posting related grievance, promotion related grievance in civil service. So when someone has promotion related grievance, posting related grievance, so it does not demand legal scrutiny. It is more administrative in nature. So if we have some members who have administrative experiences and some members who are judicial, so that the process is judicial in nature, so then we will be able to get a specialized adjudication and very speedy manner. Because it is a case related where that cost effectiveness is also important. Otherwise there will be, means you are a victim also and you are bearing cost also. And speed is important because promotion. So promotion related matters should be decided today immediately. If it is decided after 10 years, you are already retired. Right. So what you will do? Or tax related dispute. So you have tax related dispute, company law related dispute. So it is business related, commercial nature. If it is not decided early stage, so your business interest will be lost, or there will be loss of business. So, and these things demand less legality, more technicality related to taxation. The taxation related experiences. So the administrators are the members having, let's say, experience in the field of tax administration. So they know the nitty-gritty things of tax administration. Right. That's why half members should be judicial, half member can be specialist from the respective sectors. This. So the first thing it has happened that it is not about, it is not speed and efficiency as first place. At first place it is that some cases do not demand at all scrutiny by judiciary. Rather they demand specialized adjudication. And in that specialized adjudication we can introduce certain legality so that it matches the standard of judiciary. That's why it is judicial in nature. Since let's say that in tribunals it is also that you can also represent your case. Means a legal arbiter means an advocate is not a necessary condition. Means an advocate, although it has become a culture that it should be led by an advocate, but it was designed in such a way that the both sides should be heard, not by application of civil procedure code but natural justice. What is natural justice? The natural justice is that both sides are duly heard. Both sides are duly heard. So the tribunals will simply, what they will do is that they will hear the both sides. Okay. And on the basis of hearing of both sides, they will pass their order. This is called natural justice. But civil procedure code, it will take its own time. Hearing both sides, it will take time. And both will not be directly heard, but rather with your legal representative. So advocate will represent. Let's say consumer forum court. If you go in consumer forum court, so both sides will directly, let's say, that be heard. This. So it is not necessary that we can consider. Natural justice means this, that both sides would be heard, and on the basis of hearing both sides, orders should be passed. But in civil procedure code or in judiciary, you are not directly heard, rather you are represented through your legal representative. This. So this difference happens. So it is expected that when both sides will be heard, so in 1 and 2 hearing, the matter would be, and when matter will be adjudicated in 1 and 2 hearing, it means the members who are hearing that cases, they should have experience in that field. When they have experience in that field, so they know consumer related, let's say many things you should know. Consumer related rights you should know, consumer related problems you should know, consumer related what is happening nowadays you should know. If you have your experience working in that field, so you know about the companies, you know about the consumer, you know about what consumers' rights and how usually they face problem. This, and that is how we can consider need for that. Yes, certainly from today's perspective, if you see, it will also reduce judicial burden, and that's why, let's say, tribunals were created. Right. So let's try this further.
So how far we can say that the powers of judiciary and quasi-judicial bodies are co-matching?
Yes, further discussion will tell. Right. So let's try that. Bases are sources of creation. Bases are sources of creation. Although the Constitution did not mention about tribunals, quasi-judicial bodies, but 42nd Amendment Act added Article 323 A and B. Article 323 A and B, capital A, capital B. 300A was for creation of 323A was for creation of administrative tribunals, and B was for other tribunals. Other tribunals. Accordingly, the government of India introduced National Tribunal Act for creation of Central Administrative Tribunal and State Administrative Tribunal in 1985. As statutory bodies having constitutional recognition. In fact, thereafter, Tribunals have been created. Tribunals have been created by a separate law. Separate law like Company Law Tribunal Act, National Green Tribunal Act, National Green Tribunal Act, etc. And therefore, tribunals are quasi-judicial bodies. Tribunals are quasi-judicial bodies or statutory bodies. Statutory bodies. Statutory bodies. Let's see. Growth and evolution of tribunals. Growth and evolution of tribunals. Tribunals or quasi-judicial bodies. Quasi-judicial bodies. Largely they have seen their growth after 1980s. After 1980s. Of his National Tribunal Act 1985. 1985 was a major development. Major development. During 90s, due to new economic reform, there was increase in creation of regulatory institutions. And 2000 onwards, concerns for protection of environment, intellectual property, protection of environment, intellectual property, cyber threats, etc. have given rise to creation of several tribunals that once it was estimated that there were over 100 tribunals in India. Tribunals in India. The major tribunals are National Green Tribunal, Central Administrative Tribunal, Company Law Tribunal, Change the paragraph. When tribunals were created, largely they were given those cases which were dealt by high courts, high court. And hence, in a way, they were given jurisdiction over They were given jurisdiction over cases dealt by high courts. Cases dealt by high courts. That's working of tribunals. Working of tribunals. First, they have minimized burden on judiciary by speedy adjudication. Speedy adjudication. Next, they have reduced cost of adjudication. Cost of adjudication and have promoted natural justice. Natural justice. They have given some innovative judgments in their respective sector like CAT for civil servants, and NGT for protection of ecology and environment. Protection of ecology and environment. Next, their rate of disposal of cases. Their rate of disposal of cases is better than regular judiciary, and they have less number of pending cases. Pending cases. Next, however, they have been criticized for following reasons. So let's start criticisms and weaknesses. We are trying to give a general outlook, a general overview of topic, then we'll take one by one specific cases. This. Like first, they are criticized largely for three important factors. First, independence. Second, efficiency. It's speed and efficiency. What was the third point we wrote? Yes, natural breach of separation of powers. Breach of separation of powers / violation of natural justice. Violation of natural justice. But other problems are next, not good quality of judgment in general. Not good quality of judgments in general. Next, their judgments are in camera. And hence not given wide publicity. Like judiciary. Next, increase in number of tribunals. That there are more tribunals than high courts. Which is also considered as tribunalization of adjudication in India. Tribunalization of adjudication in India. We expect a question also on that. Therefore, let's say, on the basis of their problems, following questions have been raised and suggestions have been given. Like first, should they be restructured to minimize their total number? Next, should there be an apex body? Known as National Tribunal Commission, which should be responsible for protecting independence and promoting efficiency. Next, do tribunal, or let's say that whether tribunals are needed when their appeal go to high courts. Whether tribunals are needed when their appeal go to high court. In bracket L. Chandra Kumar judgment. (1997). We expect this question. It is very popular judgment. It is just a matter of time when they will ask. So these are some questions related. So just I gave an overview. Let's say that tribunals. So why we need tribunals, that we have told. Then we have tried to see whether there is any constitutional reference. So we did not have in original part of our constitution any such reference. It was done by 42nd Amendment Act 323, A and B was added. And in that edition, let's say A is meant for Central Administrative Tribunal, which question they have asked. You should know that. Means UPSC has asked a very difficult question. That was very difficult question for GS candidates because tribunal to वो general नहीं जानते हैं तो CAT के बारे में क्या जानेंगे. Although they may have CAT in their house. So this should not. Their general level of knowledge is very poor in case of tribunals. But it was a very specific question. उतना difficult question तो optional में कभी नहीं आया है. This you should know that. जीएस में टाइम्स यूपीएससी आज सच डिफिकल्ट क्वेश्चन कि इवन ऑप्शनल वे में नहीं आया. उन्होंने कैडर एलोकेशन पे एक क्वेश्चन पूछा था 2013 में, वैसा क्वेश्चन कभी ऑप्शनल में नहीं आया. राइट. Anyhow, so that's why we'll take separately. Otherwise, we did not teach. Means we don't know to what extent they are going to ask. Na? So when they ask Central Administrative Tribunal, then we came to know. Oh, means we will have to teach that also. Right. This otherwise tribunal is finished only, and NGT can be further taught. Right. So, in general, what happened that we created by 42nd Amendment Act the two references, but those references are just only for recognition. Then one is for CAT, but even CAT is not constitutional body. They added it so that we can get recognition. That's the only significance. But they have been created by Act of Parliament, not Act amended in the Constitution. So since it is created by Act of Parliament, so it is statutory. Therefore, most of the tribunals are created, means our tribunals are created by Act of Parliament. That law will define their power, function, role, responsibility, other service conditions. Like say Central Administrative Tribunal, that we have CAT. Similarly, State Administrative Tribunal for states, and National Tribunal Act decides their power, function, appointment, service conditions related, all these things. So they created during 90s again, let's say that since new economic policy comes, regulatory bodies are created. Before that we had less regulatory institutions or no regulatory institutions. But after 90s you have created so many regulatory institutions. Each regulatory institution will have its own appellate tribunal. Because regulatory bodies, so they will have, they also adjudicate disputes, and when they adjudicate disputes, they are heard by the appellate tribunals. Like say in the film certification board we told, in that also it has its own tribunal. Now that tribunal is also getting merged. So according to once, let's say that in 2015 parliamentary committee report, that time it was estimated that we have over 100 such tribunals, including, let's say that they will include also generic also. Civil court wala means in general they will say that we have over 100 such institutions. Then some cases also came which will talk. So we went on creating so many tribunals. Most recent you can say that a major tribunal that has been created is called National Green Tribunal. It is a major tribunal created. Minor, so you can see that, let's say that does not. Government created National Tax Tribunal, but that was stuck by the court. National Tax Tribunal means that all tax related, direct, indirect, they will try to merge, create one tribunal. But then it was struck down by the court on the ground that it did not have independence. Same tussle is going on with present government. That they do not have independence. Once Supreme Court is stuck, again they brought. So we'll talk that chronology of it. Let's say that how it happened. As far as working is concerned, so there is no any such clear fact to tell it. Sectoral we can say, in general we can say yes, they have reduced, their speed is better than the speed found in the High Court and Supreme Court. That we can say they have reduced the burden, they have promoted cost effective adjudication, and they have played in their area, let's say some innovative role also. Like they have passed some good, let's say, orders or adjudications, like say how Green Tribunal has been appreciated. The Green Tribunal has been very active, or activism by Green Bench or Green Tribunal, that also you see this that way. But then the problems, if you see that over 3-4 decades, what are the problems that they have? The three problems which I will elaborate now, but that we added just at one place. The three major problems are that it is about independence, lack of independence. Second is called its efficiency and speed for which it was created. And since its function is judicial in nature, it should have independence like judiciary, but it has not been given independence like judiciary. And it has been created for speed and efficiency, but it has not given that desired speed and efficiency. Okay. And next it is called that it is considered also breach of separation of powers, or natural justice, which is a conceptual question, right? So then there are other problems also. Other problems are basically, you'll find that quality of judgment, so it is less scrutinized since in-camera order is given. When they give in-camera order, so hardly people come to know, and then legal scrutiny does not also happen, media scrutiny also does not happen, and that way let's say that their quality is questionable. So you have major tribunals there, let's say quality you can have, but other tribunals, so hardly you know that whether they function, they do not function. So they remain outside, out of media purview or debate and discussion. Like say when Supreme Court gives a judgment, it is scrutinized threadbare. They may come to know also that whether they have given a right judgment or they have given a wrong judgment, right? Or what flaws they have. But in case of them, it is hardly, let's can see this. And then we have told too many regulatory institutions, too many tribunals are created, means they have become more than high courts. Right? So high courts more, so it is tribunalization of justice. How it is tribunalization? So whether tribunals have become way to bypass judiciary. But tribunals have executive dominance. Whether tribunals are in a way to minimize the powers of judiciary, take away powers of judiciary, take away power of judiciary and adjudicate in executive way. Right. So that is called tribunalization as a phenomenon. So these are some of the overviews. Then we'll take this question that we have told L. Chandrakumar. So this will give you more clear understanding. Let's take what we are saying. Why they lack independence.
So what is the meaning of in-camera judgment and how is it different from the judgment that's
what we are saying?
What is the meaning of in-camera judgment?
Right. In-camera judgment is called that it is called media is not allowed to access that this open court judgment. The Supreme Court, High Courts, they have open court judgment. The judgment is accessible to media, but their judgment is not accessible to media. This is how in open camera and open court, in camera and open court. Yes.
So does the appointment have independence or it is dominance of the executive?
That is what we are doing. Right. Why they lack independence? Let's write on that. Since quasi-judicial bodies have taken over or take over the cases of high courts, then therefore they must have independence. They must have independence of judiciary, because those cases are meant for adjudication by judiciary. Change paragraph. Judiciary has been given independence. In terms of appointment, security of tenure, finances. Therefore, quasi-judicial bodies should also enjoy similar Characteristics of independence. Like first, the selection should happen through a selection committee. Selection should happen through a selection committee. So selection committee. We should have judicial members. Judicial members. Next, the tribunals should be given long-term tenure. Long-term tenure. Next, their service conditions should be clearly defined. Service conditions should be clearly defined. Clearly defined. They should have guarantee for their finances. However, in actual practice, following things have been observed. Following things have been observed. First, even if Supreme Court has laid down guidelines for appointment process, but they are not necessarily adhered. They are not necessarily adhered. Like in selection committee, there is executive dominance. Selection committee, there is executive dominance rather than judicial dominance. Judicial dominance. Next, even serving bureaucrats have been appointed as member of tribunals. Serving bureaucrats have been appointed as members of tribunal. Next, frequent transfers. Frequent transfers of members. Even, let's say, even the present tribunal restructuring bill, even the present tribunal restructuring bill 2021 was struck by the Supreme Court. On the same ground that its past guidelines have not been adhered. Its past guidelines were not adhered. Supreme Court in past also struck National Tax Tribunal on the same ground of lack of independence. And therefore, tribunals are not as independent as high courts, but they adjudicate cases related to high courts. and hence several suggestions have been made. Several suggestions have been made for ensuring independence of tribunals, including creation of National Tribunal Commission. National Tribunal Commission, which will deal, let's say, that later on. Let's write next. Speed and efficiency. Speed and efficiency. It is one of their main objectives. It is one of their main objectives for creation. However, they have not delivered as it has been promised. Like before Tax Tribunal, there are over 90,000 cases pending. Before Tax Tribunal, there is over 90,000 cases pending. Before CAT, there are over 50,000 cases pending. 50,000 cases pending. As far as other tribunals are concerned, including consumer forum courts, their conditions are very worse. Their conditions are very bad in terms of, first, physical and financial infrastructure. Next, their staff and members. Next, institutional capacity to deliver. Even it is found that some tribunals are single member and also single member bench. Their members are also retired judges or civil servants, which also affect efficiency as oldest members lead institutions supposed to give judgment with speed and efficiency. Who has told to follow this trend? I say generally, let's say person is retired person, he is, let's say, walking like this, sorry to say that. So वो मान लो कोई केस आएगा, उनके घर में कोई बातचीत करने वाला है नहीं, आपका केस मिल गया, तो इंस्टेड ऑफ डीलिंग योर केस they will share it, their family matters. Right. They will start sharing their administrative experiences. हमारे समय में ऐसा होता नहीं था. Right. So this is what we know that कि why you have adopted this system. It is, there are recommendations कि 10 years experience enough. You should appoint people those who have 10 years of experience. Right. Recently Supreme Court has suggested that any advocate who has 10 years of experience as an advocate should be considered for tribunal. Now government has included the 10 years of experience. A person who has minimum qualification for UPSC member is 10 years. Right. Any person who has 10 years of experience working in government of India can become member of UPSC. This we have to understand, that youngest member, means institutions are supposed to go for speedy adjudication led by retired people. How it is possible? If you are efficient, that's a very different thing. But अभी तो मान लो लाइफ एक्सपेक्टेंसी बढ़ गया, पहले तो 60 से भी कम था. No, average life expectancy was 58 years. Right. आजकल पता नहीं, हम लोग in our time when we used to prepare. So 58 years. Retirement age is 65 years. And after 65 years, you become member of tribunal. So this is what you have to understand. Then basic infrastructure नहीं होता है उनके पास. आप अगर consumer forum court में जाएंगे तो पता ही नहीं चलेगा कि वो court भी है. It's like court something. Like it will consume you rather than, let's say that. So consumer forum court, this will find. Right. So some major tribunals can have good, but they are not all 100. Major tribunals, you know, the major can be CAT, it can be Green Tribunal. But other tribunals, even they have 1 member, 2 members. They don't have adequate staff. They don't have typing machines. Right. You need in office, let's say office infrastructure इसको बोला जाता है. Office infrastructure, physical, financial, all these things. Trained personnel. So जब major institutions headless होते हैं तो ये तो shadow area में आते हैं. Right. Major institution like CRPF is headless for few months. Right. 40 PSUs are headless for, let's say that. So CBI director is acting director. So when major institutions are, let's say that, suffering from this, already we have told about judiciary. Judiciary is itself suffering. Like so जब high court suffer कर रहा है तो इनका status तो lower than high court. So their capacity to deliver is questionable. It is a major, let's say that, problem. Unless they are given trained staff, adequate infrastructure, and members with some, let's say, young member, so their, let's say that, efficiency will suffer. It was expected that they should take 3 months plus 3 months. In general, let's say that 3 months plus 3 months means 6 months. Basically, they are supposed to give judgment, let's say that, in 6 months. But you know that average commercial adjudication case average, it takes 4.5 years. Once I taught ED topic 3 years, 4 years back. So that I remember the commercial adjudication. The commercial adjudication, you know that, done by tribunals, specialized, it takes 4.5 years in India. That's why commercial arbitration is, government is focusing more on that. So this, and the cases are pending even before good tribunals, let's say, Central Administrative Tribunal, you can say, over 50,000 cases are pending before this. It was expected that they should not have advocates, rather people should themselves represent But it has become, let's say, another regular court where people do not represent, rather they send their advocates. And when advocates will enter in any such premise, you know what will happen. So postponement of cases, that happens. So this is what we'll find the speed and efficiency aspects. That's why it is one such logic that government wants to reduce their number. This you should know that. Their number should be reduced so that we can enhance their administrative infrastructure. This. And the last, let's take this called last, what we have? Breach of separation of powers. Let's say for one more point we'll write then. For addressing speed efficiency problem. For addressing speed and efficiency problem. Speed and efficiency problem. There are also recommendations. There are also recommendations. That first, their numbers should be restructured, their numbers should be minimized. Their numbers should be minimized. Second, there should be All India Tribunal Service. All India Tribunal Service. Like Constitution of National Tribunal Commission. National Tribunal Commission. The present government has also introduced a bill National Tribunal Bill for restructuring tribunals. Let's read next. Whether they violate separation of powers, oblique natural justice. Natural justice. Since there is separation of powers. Separation of powers among the three organs, and also Article 50. And also Article 50. Which talks about separation of executive powers from judicial powers. Judicial powers. Tribunals are viewed as breach of separation of powers. Breach of separation of powers because of following factors. First, half members are from the executive side, which include specialists and bureaucrats. Next. Executive is the appointing authority. Executive is the appointing authority and tribunals do not enjoy the same standards of independence enjoyed by high courts. High courts. Next, one party before tribunal is state. One party before tribunal is state. That is, tribunals deals with adjudication of those cases which are between government and citizen. Or related to government departments, including service conditions. And hence necessarily one party would be the government. Therefore, in a way, there is presence of executive in its own dispute resolution, which is like becoming judge in one's own case. And since tribunals represent mixed type of characteristics, hence it is breach of separation of powers. फिर क्या करना चाहिए? No. See, there should be separation of executive power from judicial powers, judicial powers from executive powers. But here you are bringing both together.
So who will you be? Judiciary for breaching or executive?
No. First we have to know why it is breach. The breach because it brings both powers. Plus executive is the appointing authority. The executive dominates in that appointment. It selects, let's say, half members, non-judicial members. So half members, judicial members. In that, judiciary can have a say. But half members are non-judicial, specialized members. For specialized members, the qualifications are not clearly defined. And as I told that, even serving bureaucrats are appointed as member of tribunal. So you know what serving bureaucrats will do that. So there is very much presence of executive. So it is blurring the distinction rather than segregating the distinction. So separation of power this is how there is breach of separation of powers. Plus natural justice is that you should not be judged in your own case. But you are the appointing authority and you are necessarily one party. Just imagine Central Administrative Tribunal. The Central Administrative Tribunal. So, and you are a civil servant, and you have been transferred. You have challenged in the Central Administrative Tribunal. So, CAT members are appointed by the government, and government has transferred you, and you have gone against the government in that court. So, do you expect that they will give the order in your favor? Right. Green Tribunal. So, project contract has been given by the government, and a citizen goes that the contract or project is affecting ecology, and government has appointed the Green Tribunal, and you go, government has given go ahead with that contract. Government does not find that there is any problem. So it has given contract, and against that contract you are going to an institution appointed by the government. So it is natural justice violation. No. Should we have any, do we have any strong reasons to refute all these things? What do you think? Can we refute? Or we cannot?
Refuting this is demolishing. So we are created for reducing the burden.
Yes, so even if let's say that it is violation of natural justice and separation of powers, but still let's say that they are needed. The need is more important, this you should know. Their role is very important. We can address the problems of natural justice and separation of power problems by making tribunals independent. That is the only solution. If we keep tribunals independent, hence this problem will not come, because even in judiciary also judges are appointed by government, and one party is government in judiciary also. No. So it means we cannot completely, absolutely avoid natural. That means we cannot absolutely practice natural justice. And that can be done by if we make tribunals independent. That's why independence is important. If they are not independent, so this is how executive can. Executive को अगर किसी केस को avoid करना है, तो it can create tribunal, so that the matter should not go to judiciary. Although it is a very hypothetical thing, but that is how you will find that tribunals are gradually you take away the powers of judiciary. The more and more tribunal, more and more creation of tribunal means more and more taking away of power of judiciary from judiciary and giving to tribunals. That's why this means the phenomenon of tribunalization should be reversed, and there should be greater level of independence, transparency, accountability in the process of working of tribunals. That way we can deal. And we cannot completely avoid this. If there is independence, so then it can take care of breach of separation of powers. So there cannot also be complete separation of powers. The ultimate task is speedy adjudication. Right. So this is what we should talk. So let's.
In the members of the tribunal, what is the ratio from the executive side and from the judiciary side?
It is almost half from the judiciary side, half from executive side, which will include specialized members and bureaucrats.
And if a case is taken to the tribunal and it has to be performed in a benches, right?
Yes.
So in a bench itself, what would be the proportion from the executive and from the judiciary?
It can be 2 member also, it can be 1 member also.
More members are from judiciary and less from the executive.
No, no. Even there is a single member bench. This you should know. There is a single member bench also. Although the benches of major tribunals are defined, like say CAT. Right? The CAT, if you take, it has its benches along with High Court. And there, let's say they have adequate members. So their number of members are very huge. So when you have huge number of members in that body, so then there is no problem like you have only 1 member or 2 members. So they will have defined benches. In Green Tribunal, it will have defined benches. But other tribunals, let's say that Consumer Forum Court, पता चला कि एक ही member है उसमें. You have a District Consumer Forum Court. The District Consumer Forum Court, do you have, how many members are there? So you may have 1 member only. Telecom Appellate Tribunal, how many members you have? So it is not known. Right. So other tribunals, we do not know that whether they have adequate members. When they do not have members, they are forced to have 1 member bench. Right. Ideally, when there are 2 members, the one is from a specialist side, one is from judicial side. Right. It is also not necessary that you will appoint bureaucrats, like say National Green Tribunal. So you can have specialist members in the field of environment, ecology, etc. Plus judges, sitting retired judges you can have. So it is not necessary, but yes, the less known tribunals have bureaucratic members. So we do not talk about 1 tribunal or 2 tribunals, no, we talk in general.
So what if the members of the judiciary is increased and from the executive side the capacity is reduced? So then the judgment will be in balance?
No, it is not, let's say, it is not needed. Rather you find the, see, you cannot have absolute level of independence. But yes, if अगर कोई project है, if any project is having let's say negative environment, means its repercussion, so certainly if the bureaucrat even knows that he should go by the facts. तो फेवर ऐसा नहीं होना चाहिए कि you go against the facts. Right. Yes, on quantum of, let's say, order or nature of order, you can become harsh and soft. But means it's like you should not become blind follower or supporter. Otherwise, then why you need expert members? You appoint party members. This, because today you can find that any project and that project is causing any environment problems, so, and today you manipulate it and manage it, but then always it is, let's say that a sword is hanging always over that. Judiciary can anytime can cancel the project. क्या पता कोई petition direct Supreme Court में ही फाइल कर दिया. यह सिचुएशन यहाँ तक आ जाता है कि means direct evacuation. Project would be stopped. So why you reach to that level? That's why, let's say that we told in judiciary case, and we will tell in other such cases also, we need to have a robust system of appointment, because it is related to different sectors, different institutions. Every that institution, major institution where government has to appoint, ensure independence. So if it does not have robust system of appointment, so ultimately it will itself suffer from its lack of achievement of objectives. Because ultimately all these institutions contribute, then you progress in desirable manner. Main aim is only not just GDP growth rate. This, you should know that a society grows, like it's not about that making India economic superpower. It, let's say, making India or a country making happy society, a prosperous society, right? Rather than, let's say that a powerful society. Right? This, and that is how these institutions contribute. If you have created National Commission for Scheduled Tribe and you pata chala ki you have not appointed members who are competent, they do only lip service, so what will happen? The grievances of scheduled caste will pile up. Grievances of scheduled tribe will pile up. Grievances of OBC will pile up. And when it is pile up, so next day you know what will happen. After some time they will not go for grievance, they will go for protest. और एक दिन जब प्रोटेस्ट हो जाएगा पूरे हरियाणा में, थ्रू आउट हरियाणा, सो इट इज 2000 करोड़ लॉस एस्टिमेटेड. बाकी तो लॉस रियल में बहुत होता है. 2000 करोड़ लॉस. 2000 करोड़ में आप बहुत सारे इंस्टीट्यूशन, सारे 100 इंस्टीट्यूशन आप रन कर सकते हैं. It's about thinking that how you create a society and protect your resources, and income saved is income earned. So we should not only focus on earning and destroying income, rather saving, and that will also reach. It's broader way to think. Let's write down this further.
So mostly by the establishment of tribunals is the most benefit for people or ruling governments.
It's not about ruling government, because a ruling government has nothing to do. Already they have been created. Basically they are created to minimize the grievances of people. Basically they are institutions to minimize the grievances of different categories. आपका टैक्स रिलेटेड ग्रीवेंस है, किसी का रेलवे फेयर से रिलेटेड ग्रीवेंस है कि आपका फेयर डिडक्ट हो गया एंड आपका टिकट मिला नहीं. तो उसका भी एक ट्रिब्यूनल होता था, रेलवे रेट्स ट्रिब्यूनल. अब पता चला कि टिकट तो 500 का है और ग्रीवेंस रिड्यूसल में 1000 खर्च हो गया. What you will do? Right. So grievance, yeah, product consumer court, product cost is 5000, fighting cost is 10,000.
Finally government is getting benefit.
Right. So no, but that ultimately, let's say that कि creates bottlenecks in society. Society को वो grow नहीं करने देता है. Right. This it will not let society grow. Like जैसे कि consumer है, आपका rights violate होता है, तो आप complain नहीं किए, तो नहीं किया तो जो company consume supply कर रही है ना, that will not innovate. It will keep cheating you. This. So ultimate analysis is that it keeps society in a bottleneck kind of situation, right? And it's, let's say, somehow consumes people energy, mind, energy, efforts unnecessarily. That's why various types of, let's say, you are as a civil servant. So when you are a civil servant and then you have, your promotion was due, you have not been. So your grievance should be immediately redressed, whether you are given promotion, you are not given promotion. Otherwise you will get demoralized. Once you are demoralized, huge loss to the government itself. You will derive salary without work. Play golf. Right. That is how. So many civil servants join to work for people. After that time they start playing golf. Right. Because they know that कि right, कुछ होने वाला नहीं है, तो बेहतर है गोल्फ खेलो, एंजॉय करो. अरे ऑलवेज. Yes, even if it results into, even if it results into violation of natural justice, and violation of natural justice and breach of separation of powers, still tribunals are important, and their creation can be justified on following grounds. First, there cannot be absolute level of separation of powers. there cannot be absolute level of separation of powers and avoidance of natural justice. Natural justice. Next, even in case of judiciary, the executive is the appointing authority. The executive is the appointing authority. Next, the cases are related to less legality and more specialized in nature. Next, if quasi-judicial bodies are given independence, like judiciary, then there will be less problems of violation of natural justice and separation of powers. Because they would function on the basis of independence and decide cases on the basis of merit. And that's why independence becomes an essential condition. Let's write L. Chandra Kumar case. 1997. When National Tribunal Act 1985 was introduced for creating central administrative tribunals. And state administrative tribunal. Then the cases from high courts were given to cat and sat. It means they were given jurisdiction of high court. And it was stated that the appeal would directly go to Supreme Court. About cat and sat. They are statutory bodies. Created under Administrative Tribunal Act 1985. Administrative Tribunal Act 1995. They have following characteristics. Following characteristics. See, national, when you have written National Tribunal Act, you change that Administrative Tribunal Act. Right? It is Administrative Tribunal Act. First, they are multi-member bodies. Multi-member bodies. Next, appointment is made by President. Made by President. In case of CAT, in case of SAT, by Governor. Next, they enjoy security of tenure. They enjoy security of tenure. Security of tenure as within that first, their grounds of removal are mentioned. Grounds of removal are mentioned. Next, President is the removal authority. President is the removal authority. Next, jurisdiction. Jurisdiction. They deal with conditions related to civil services. Conditions related to civil services, like recruitment, posting, promotion, remuneration, transfer, etc. Their powers, they have civil court powers, and half members are from judiciary. Half members are from judiciary. Most of the CAT benches are at high courts. At high courts. Next. However, tribunals face legal ambiguity. Before the final verdict was given. Before the final verdict given in L. Chandra Kumar case. L. Chandra Kumar case. Although they were meant for speedy adjudication, but L. Chandra Kumar judgment in 1997 gave legal clarity about the relationship between high courts and tribunals. tribunals. The legal ambiguities were related to. The legal ambiguities were related to first, whether tribunals are subordinate to high courts. Tribunals are subordinate to high courts or equal in status. Equal in status. Next, whether direct appeal will go to High Court or Supreme Court. Next, whether tribunals are substitutes of High Court. Whether tribunals are substitute of High Courts. High Courts. Next, whether tribunals can deal with substantial question of law. Substantial question of law. These are the legal questions. That's why this case is important. So every sector has its own case, landmark case, ordinance, DC Vadhva case, president rule, so SR Bomai case, and if you take tribunals, so it is L. Chandrakumar case. That's why we have been expecting L. Chandrakumar. So ambiguities were there. What exactly should be the relationship? Since tribunals were created, several commissions, law commissions also recommended in past about this, including ARC first also recommended. That is not needed to know the history like this. But you know that in past efforts were made after independence by law commission also, 1-2 other committees also, ARC second also recommended that we should create tribunals for alternative dispute redressal. Finally, 42nd Amendment Act added this. Thereafter, Administrative Tribunal Act 1985, an important step was taken. And then disputes also started surfacing. The disputes were related to that when tribunals are being created. Since High Court's cases were transferred to tribunals, before that they were dealing those cases. So when High Court's cases are being transferred to tribunals, so whether they are equal to High Court. That if they are equals, it means whether they are substitute of High Court. And when they are substitute of High Court, so can they have can they deal with a substantial question of law also? Because High Courts deal with also substantial question of law. So these things came, and in L. Chandrakumar judgment it was made clear. But before that, let's say that the above factors were also dealt by Sampath Kumar case. Sampath Kumar case, in which Supreme Court stated that first, tribunals are substitute of High Courts. They are alternative judicial adjudication system. Next, it justified tribunals' direct appeal to Supreme Court. Supreme Court. Let's say Sampath Kumar case is largely known for, change in paragraph, Sampath Kumar case is largely known for pronouncing a judgment in which it considers tribunals as substitute of high courts. Tribunals as substitute of oblique alternative to high courts, which was struck by L. Chandra Kumar case. Let's say L. Chandra Kumar case. L. Chandra Kumar case. The Supreme Court gave following orders. First, tribunals are not substitute to high courts, rather subordinate to high courts. Subordinate to high courts. Next, the first appeal from tribunals would go to high courts. The first appeal from tribunals would go to high courts and then to Supreme Court. Next, since high courts enjoy power of judicial review and also deal with fundamental rights, substantial question of law. Therefore, under Article 226, high courts have power for judicial review of tribunal cases. High courts have power for judicial review of tribunal cases. Next, tribunals must enjoy independence. For which it also laid down guidelines. So simply let's try to understand that. What it says that when high court's cases are transferred, high court's cases are transferred to tribunals. Now, high courts, they have also power under Article 226, 227, other, let's say that they deal with various types of cases. Now these cases may also involve the cases which are getting transferred. So in that way, when you are transferring those cases to tribunals, that without invoking them is kind of bypassing of high courts. Because high court has been given this power, not tribunals. So when tribunals are dealing those cases which may involve, may not involve that, may involve, may not involve, but if direct appeal goes to Supreme Court, then if those cases are involving this, so in a way it is like substitution. Right. Hence, high courts should have jurisdiction over tribunals. They should not be considered as in the substitute. Why? tribunals, no matter how much independence you give, they cannot be having equal independence like high courts. Right. And when tribunals deals with questions related to substantial question of law, or when they deal with any such matter which may also involve fundamental rights or judicial review, so they are playing that role without having independence like judiciary. They have not, because half members are from executive, half members are also retired. They may be sitting are retired, but largely it is retired members. Appointment is not the way it is in judiciary case. Then the conduct rules, etc., charge consolidated, means simple, let's say that ki high courts enjoy independence, and hence they have power to have judicial review, including related to Article 226, when directly citizens can go to the high court. But when tribunals are created, first they are created not under constitution but rather under statutory provision, and then they also have the characteristics of executive, but they are dealing the matters related to the high courts. The logic of Supreme Court was that ki no, since they are dealing with matters which were dealt by the high courts, but they do not enjoy the similar independence, hence they should be the first line of scrutiny going to high court, and they should not be considered as substitute of high court. This, and that's why it assumed, from technical point it assumed importance. L. Chandra Kumar case. Why we are giving so much significance? Because इसके बाद का जो question होगा वो इस पे प्रॉब्लम क्रिएट करेगा, ठीक. सो उसके बाद का क्वेश्चन जो है वो बवाल मचाएगा, राइट. वो ये है कि जब अपील हाई कोर्ट्स को ही जाना है तो why to create tribunals? This. So should we create tribunals? And two states went on abolishing. One was Andhra Pradesh, next was Madhya Pradesh. Right. Two states merged there, matlab they sat, they abolished. They told that if High Court has to deal, let it deal.
So many cases are going to be tribunals.
Right. This. So that puts into dilemma that this is how question is asked. That is how it is an important judgment, and a question is often asked like this. Right. So how will justify?
He will be present in society. So otherwise the problems will not be open.
Yes. So what we will deal?
So usually, like, people appeal when they are not satisfied with the judgment of any body. So we can.
Then it demands some facts to prove your point. Right. We cannot compromise. You know, we told in case of fourth judge's case. Independence of judiciary is non-negotiable. You cannot negotiate independence. So that is how judiciary try to again protect its independence. So even at the cost of delay, we will not tolerate, right, or compromise our independence. It is good also, let's say. So this. Then it was observed that when tribunals were created in 85 and till 1997, so how many cases were transferred from High Court to tribunals? And in that case, how many cases were transferred? How many cases were appealed to High Court? And when they were appealed to High Courts, in how many cases High Court passed order similar line of tribunal? Right. That level of analysis have been done.
But what is the logic behind transferring from High Court, then again giving a judicial review to High Court for
Yes, because justification will be on the ground. And see, tribunals will deal at their level on the substance of the case, on the basis of their expertise, field expertise, right? Now when it will go in high courts, it will have only legal scrutiny. Right? Does it involve any substantial question of law? Does it involve jurisdiction of Article 226? Right? They will not go into the nitty-gritty substance of the case. So when they would not go into the nitty-gritty substance of the case, as it has already been done by one court, hence it would not take much time. This, and that way it is justified. Directly going to Supreme Court, then Supreme Court will be doing the role of High Court. It will take its time also. The burden on Supreme Court will increase. That way also it is justified. And it is essential that since High Court's power have not been given to tribunals in terms of Article 226, hence there should be, let's say, that hierarchy maintained. And more than 70%, means exact fact I will tell you tomorrow when we will dictate, more than 70% cases or 80% cases going to Supreme Court, High Court from tribunals have been given judgment in their line. It shows their good standard of judgment also, and it does not take much time also.
So what if tribunals are given independence and they are made as in...
No, still it will not be. Rather you make independent and you make enhance the capacity, it will bring speed and efficiency. No, if you improve independence, if you enhance the capacity of the tribunals, they will have speed and efficiency. And once they go to High Court adopts, because it will not go into the, again, substance of the case. It will see the legality of the case. Right. And then it will pass its order. Again it is approving, it is discouragement to appeal in Supreme Court. Right. There is a less scope that you should go again for Supreme Court, this way. So that way we should see this.
So can a body be made subordinate or alternative to High Court, but within judiciary
No.
independence?
Not possible. Not possible, so let's take tomorrow. Right. Someone has written something. Thank you for that. This is a message has been written. Yes. So let's finish it. Tomorrow we'll take it. Panel will finish tomorrow. Right?